And also, what was the answer?
The west side of the building and the north side of the building, sir.
And I believe you said that both of those face Brady Street. Is that correct?
Correct.
Okay, I have nothing further. Thank you.
Thank you.
Hang on. Cross.
Thank you. Officer, you went down the street attempting to see if you could see any cameras. Is that correct?
Yes.
Okay. Do you know whether or not any of those cameras were working?
I never got to view the video surveillance.
So, are there some times where there could be a camera on a building and it's not working?
Yes.
Okay. Additionally, you stated that you went to Dynamite and it had a camera and that was covering only the door. Is that correct?
Yes, I believe so.
Only the front entrance?
Yes, I believe so, yes.
Okay. And did you go in there by checking inside?
Welcome back, guys. Sorry for the hold up.
Notating cameras in
So
the
you
area.
looked up at the camera and it was facing just basically not at the street, but
I
at
had to
the
put
door.
out a small fire.
Yes, I believe so.
Okay.
No big deal.
Additionally, did you go and check with any of the people that may have had a Ring doorbell?
I notated that there's a Ring doorbell in the area in my report, yes.
Do you remember actually, in fact, knocking on a door of one of the addresses you just talked about and trying to see if she had any recordings?
My task was to notate video surveillance in the area for future follow-up.
United States Exhibit number 83, currently in the big screen, and it's going to be coming up here in a little bit.
Fine.
I have Officer Lorenzo Hernandez, correct?
Yes.
Okay. JR6, currently fired up on the computer, if it eventually ever acknowledges itself. Come on. There we go. And if
The
we are
prosecutors
looking
having
here,
computer problems too.
just going back a little bit, was, and let's say starting at 1 minute and 4 seconds into the recording, was 8:30 one of the addresses you took a look at?
Yes.
Okay, and as we can see, that's a Ring doorbell, right?
Yes, in the video.
And on the video, we can actually see, you did more than just note it, didn't you? We got someone coming to the door.
Yes.
Okay. I'm going to play from this portion at 1 minute and 6 seconds.
What exhibit is it again?
83, Your Honor, I apologize.
83.
Pausing at 1 minute and 13 seconds. We actually hear you say, sorry to bother you again, right?
Yes.
Okay, so you've been there once.
Little miss, if
Now
you
you're coming back
subscribe
for
to
these,
me,
right?
you can
Correct.
should be able to find me on my
Playing
subscriptions.
from 1 minute and 13 seconds into the
Yeah,
recording.
I'm sorry, Cheryl. That happens when you're a brand new channel.
Just actually registered.
Once I get big and bad like everybody else, you'll be able to find me super easy.
Okay, that's okay. When you get video, like when it records, like how far out does it record? Does it record like every person that walks by?
I have it set just to like this front area, but it goes off every time the bus comes through.
Okay.
So
Does it actively record, or do you only get live view?
yeah, so I only get live view.
Okay.
Pausing at 1 minute and 47 seconds. So just so we're clear, we can see that you actually did follow up to see if you could get any video recording, at least from this one Ring video.
So this is my body camera, is that correct?
Yeah.
So I believe it was Officer Wilbur that said, so we're here to speak with you.
Hang on. Slow down.
Oh, sorry about that.
Yeah, that's
Take your
hearsay.
time. Then you use your alter voice. Speak. Go ahead.
I believe it was Officer Wilbur that said, we're here to speak with you again. So I'm not sure if he may have made contact with the individual, or I don't recall if I was the individual that walked up to that door and knocked on that door. So it may have been Officer Wilbur, correct?
So at least what we have here, though, is both you and your partner checking up to see if maybe there was a recording, right?
Correct.
They don't have a recording at this Ring video, correct?
I believe she said it did not record.
Not all
Did not.
doorbells do
Your Honor,
recording.
the state
Some
would
just do
move
live
that portion
video.
of this video in evidence.
Received.
Just a further showing that this
Nothing else. Thank you.
missing evidence doesn't
Anything else
actually
from the
exist.
defense?
Just a little bit. Officer Hernandez, you said that that was actually the body camera of your partner, Officer Wilbur? No, he said it was.
No, that was my body camera.
But he was the one who was speaking on that clip that we saw?
So based on watching that clip, he stated that, "I'm sorry, we have to come and speak with you again." So I believe he was the individual who may have knocked on there in the first, like, initially. So based on just watching that brief clip, I probably went up there with him again. So
You guys did a thorough job with your task in terms of going down and noting all the locations, right, that were there on Brady Street going from Holton to Humboldt. You would agree with that, right?
what is your question? I'm sorry, I can't rephrase.
My question is, you did what you were supposed to do as part of your task, and then you handed, after noting,
Objection, leading.
Sustained. It's your witness. But let's get to the point. Again, we are really beating this dead horse over and over and over.
okay,
And I'm tired of the beatings going on.
just two more questions really briefly then, Judge. 830 East Brady. Can you confirm that it is basically west of Marshall Street?
This is not
It
working.
would be west of Marshall Street.
For fuck's
Can you
sake.
point that out to us just by
You-
going up
This
there?
is not helping you guys. Stop. I apologize for swearing, but these guys are bad. And I don't know how else to describe it.
Sir, why don't you have a seat again and answer the question, please, or make that statement, please?
Okay, is that
Can't
830?
make the numbers up. Could you bring those up to me
Yeah.
again?
Do you see 830 East Brady Street marked there, officer?
That'd be approximately.
Sarah, it's not a
Okay,
bias.
so
He's
it's
just
slightly east of Casablanca, is that fair to say?
Correct.
Okay, and it's not near Dynamite or Glorioso's, right? It's maybe at least a block or a block and a half from those locations. Is that fair to say?
So the 830 would be west from the 1011.
Right,
East Brady.
so going back to D26,
no. The judge correcting
830
counsel
East
during
Brady
trial is
Street
not
would be
going to be considered influencing the
right
jury.
around here, right where
I mean,
I'm pointing? which
It's
is
just
where
they're
you-
fucking up. The prosecutor's not.
Sherwin-Williams
That's the only
paint
difference.
store.
That's the only reason why it's happening.
On your diagram, some of the addresses are not notated, so I had to approximate in that area based on the cross
Correct,
street.
Google is
or
not
correction,
100%
based on the
correct.
cross numbers that were there on your diagram.
Okay. And after you made all these notations, as you said, you then forward this over to the detectives, and that was the end of your responsibilities as to the cameras, right?
To my recollection, yes.
All right, thank you. Nothing further.
Yeah,
Cross.
funny lady, he is very mad at
All right,
the
step
defense.
down, officer.
He's very frustrated,
Thank you.
beating on
Next
the same
witness.
point repeatedly.
Stephanie Trotter.
Fine.
I have been looking forward to this lady's testimony because I mentioned her before. But listen, if this prosecutor was screwing up, the judge would be coming down on him just as hard and as quickly. This guy doesn't seem like it takes very much nonsense, has very little patience. So if they'd been screwing up, he'd be crushing them too. They're just not screwing up. Yeah, and yes, all this stuff affects the jury, though, at the end of the day. If your attorney doesn't look prepared, that factors into how you're going to think and look at facts. So, I mean, I'm going to say this, but a jury trial is about sales. You're selling a story. So selling a story, you have to present a good image. If you're completely fucking it up, they're not going to focus on your story. They're going to focus on your screw-ups. Yep, I'm curious to see what's going to happen. I mean, Sarah, you mentioned that you think that should be an appeal. It's bias. I mean, if you look at the Kyle Rittenhouse trial, though, the defense was hitting it out of the park, and the prosecutor kept screwing it up. So, are you going to say that's showing bias one way or another, or the judge is just policing his courtroom? Not to be argumentative, just a thought.
Do you solemnly swear the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Please be seated. State your full name, spelling first and last for the record.
Stephanie Trotter, Stephanie, Trotter, Trotter.
Good afternoon, Ms. Trotter.
Good afternoon.
Can you tell the members of the jury what you do for a living?
I'm a CNA. I've been a CNA since about 2014, but I've been in healthcare since 2008.
Okay, and I'm going to ask if you could when you speak, just speak a little closer into
Okay, sure.
the mic, just to make sure we're catching. If you don't mind repeating your
So
occupation.
I'm a CNA, a certified nursing assistant. I've been doing that since about 2014, but I've been in healthcare since 2008.
Okay. And are you married?
Yes, I am.
And how long have you been married?
3 years, and I've been with my husband for 19 years.
Okay. And do you have kids?
Yes, I do, 6, and 2 grandchildren.
Okay. All right. Now, I want to bring your attention now to events that might have taken place on September 22nd of 2020.
Yes.
Does that date stand out to you for any reason?
Yes, it does.
Okay. And we just want to kind of just start back. Well, let's go here. Do you remember an incident that occurred on Brady Street or around that vicinity on or about September 22nd of 2020?
Yes.
Okay. And if you could just tell us who was with you on that evening?
So that evening, it would have been me, my husband, and my 7-year-old and my 2-year-old. He's 2 now, and he was 6 then.
Okay. And
the 7-year-old was 6 at the time, and then the 2-year-old was 1 at the time. So just 2 of the children was with me and my husband.
okay. And if you could tell the members of the jury, where were you coming from on that evening?
That evening, if I'm not mistaken, we were coming from Walgreens on Brady Street. But I'm not 100% sure because we live in that area, so I can't really tell where we were coming from that night.
Okay. All right. Now, on the night of September 22nd, 2020, did anything stand out to you as you were coming along or traveling in that vicinity?
Yes.
Okay. And what kind of car were you operating on that evening?
At the time, we had a 2012 Chevy Trailblazer.
Okay. We now could present what has been marked as Defense Exhibit 15. 25.
Madam Clerk, could we have the evidence control, please?
That's me that has that.
Oh, Judge?
Go ahead.
Thank you.
Travis, we'll talk about why he can't do
Now,
ineffective assistance of
Ms.
counsel.
Trotter, is this the vicinity that you recall being on the evening of September
Let me get a
22nd,
second.
2020?
Yes.
Okay. All right. Now, I want to, play parts of this video, and I would like to you to inform the members of the jury where and if you see your vehicle arrive in frame in this video. So, counsel, if you can jump to approximately 30 seconds or so. Oh, Stop right there.
Edge, you may not like him, but I like his
Okay.
suit. Very snazzy.
He went kind of fast.
Hang on. He has to ask a question.
Okay, counsel, if you wouldn't mind backing up maybe 10 seconds.
I'll move myself. Ah!
Shall I play it?
Yes.
Okay, playing at 20.8.
There's my vehicle.
Okay, can you stop right there, please? So, Ms. Trotter, are you identifying this red SUV as the vehicle you were operating on September 22nd of 2020?
Yes.
Okay. And if you can continue.
Playing at 35.6.
And stop right there.
Stopping at 40.4.
Now, at this point, did anything come to your attention at the time you were driving by at this specific frame?
Yes.
And what is that?
While my husband was driving, I was on the passenger side. When I looked to the right, it looked like a woman was maybe in distress or something was going on.
Okay. And what did you do next?
So I was looking in the mirror as we kept driving, and I just told my husband, I think something's wrong. You should turn around.
Okay. And if you could continue, counsel.
Playing at 40.4.
So is that you hitting your brake lights at this point?
That's my husband, yes.
Okay.
I stopped it at 46.3.
Okay. You can continue.
Replaying.
Yes. And is that you taking a U-turn at this point?
That's my husband taking a U-turn, yes.
Yes.
You turn across
All
two
right, you're
lanes.
taking
That's a
another
traffic
U-turn
offense.
and what's happening at this time if you stop, counsel?
At this time, I see, like I said, I saw a woman. She was standing there, and from the way it looked, she was like in distress or something was going on. So I had my husband turn around just so I could see if it was something I could help with.
Okay. Counsel, continue, please.
Playing at 112.5.
And then you stop right there, please.
Sorry, guys. I didn't realize we were still
And
going.
what are we seeing occurring at the time that you pull, or your husband pulls aside what has been identified now as Ms. Clearman?
I believe at that time I let the window down and I asked her, was she okay?
Okay. All right, and counsel, if you could continue playing the last part of this video.
Playing at 120.8. Said playing at 120.8.
Okay. Now, Ms. Trotter, I'm not going to be asking you questions that occurred after this video that's not captured on video.
Okay.
I want you to explain to the members of the jury, as your vehicle pulls up, you just indicated that you let your window down, correct?
That's correct.
And explain to the members of the jury what was said or what transpired up to that point.
I let the window down. The woman, she was like screaming and hollering. I asked her, was she okay? She said, no, someone just shot my fucking husband. So I stepped out the vehicle. My husband pulled in front of her vehicle and parked, and I approached her.
Okay. And did you observe anything else with Ms. Clearman at the time that you approached her?
I could remember just standing there asking her, did you call 911? She said no. So I began to call 911. She stayed on the phone, and I talked back. I asked her the questions that the 911 operator was asking me, and then That's pretty much how.
Okay, I want to stop real quick. You said somebody stayed on the phone.
Miss Clearman was on her telephone speaking with someone, and I called 911 and began to speak to the 911 operator.
Okay, so are you saying that Miss Clearman was on the phone at the time that you approached her?
Yes, I could hear her saying like, Anna, he shot my fucking husband, and she said it maybe like 3 times. Like, you know, like, I don't know if, yeah, she
This
said it like
isn't a
3 times,
bombshell.
so.
Now, did she appear to be on the phone with Anna at the time that you volunteered to call 911?
She was on the phone already with Anna when I began to call 911.
And what happened next?
So I called 911. I kind of explained our location and what his wife had said to me, and just let them know where we were. I believe they asked if the victim was still breathing, and was there anything she can do to walk us through, like CPR or something to that nature. It was something to those words, and I like communicated to the wife, you know, what the 911 operator was saying.
This is
she
all
answered what she
irrelevant,
could,
guys.
and then that's kind of how it went.
Okay. Now, can you describe to the members of the jury, where was Miss Clearman at during the time of this 911 call that you were on?
This is a defense
So
attorney
it was
who came up with their theory of the
Hosea
case
Brady is like some
and is
steps.
unwilling to
And if
modify
you
it or
approach
change it
the steps,
given the events at
walking towards
trial.
the steps, Miss Clearman would have been on this side, which would have been like to the far left.
You can talk in the mic a little bit.
She was in like to the far left of where the opening was on the steps. Then the victim was like laid right here, and then I was standing like right outside the opening.
Okay. And was Miss Clearman still on the phone at this point?
Yes, she was.
Okay. And you indicated that you were on the phone with 911.
Correct.
And they were giving you instructions as to measures to try to save or rehabilitate Mr. Clearman's life at this point?
Correct.
Okay. And you indicated that you provided this information to Ms. Clearman. Is that right?
Correct.
Was she responsive to any of the instructions that were provided?
I believe when the 911 operator asked what if we needed to do CPR, instructions on how to do CPR, I believe she said like he's already gone.
He had a fucking hole in his head. CPR ain't gonna do
Something
anything.
to that nature.
Okay. And what else did you observe about Ms. Clearman's actions?
At that time, she was kind of like standing up on the phone away from the body, but you know, she was just kind of like standing there and still on the phone, and I was trying to get through the 911 call.
Okay. And what happened next?
After the 911 call ended, she kind of like kneeled down towards her husband and was like trying to go through his pocket, his right pocket. And I think I said to her like, you probably shouldn't be doing that. And her words were, this is my fucking husband. And I said, yes, ma'am, I understand, but you probably shouldn't be doing that.
Could you describe when you said that she was
digging
going
through the
his
pocket?
Can you describe to
Which
the members of
pocket?
the jury what her actions appeared to look like when she was going through that pocket?
Could I stand up?
Sure.
Oh, okay.
Hang on, what was the question?
Should I stand up to demonstrate or just stay seated?
No, don't stand up. Just answer the question verbally first, please.
So she was kind of like kneeled down towards his body and like trying to go towards the pocket area. But I don't
Like the
think she
front
could get
pocket?
to the pocket that she was trying to get to.
Okay, can you demonstrate what you mean by going to the pocket? Like, what were her hands doing?
Like almost a lift position, if you may. Like, you know, like a shove almost.
I know where you're going. You need to ask her to
And
stand up and show which pocket.
You specified the right pocket, correct?
Correct, because that would have been the pocket that was closer to her.
Okay. And you sure it wasn't a back pocket or any other pocket?
I never seen her go in the back pocket.
That would have already happened, from what I understand.
And what happened next?
By then, she's standing there, and you know, I'm just asking her like,
Yep, they're trying to show she dug for
"Are
the
you
knife
okay?"
and that she knew it was there.
Was just at that time she had started to become like hysterical, like, "Oh my God, you know, my husband, oh my God." And then that's pretty much it. The fire department started coming. So as the fire department approached, I kind of, you know, I went on about my way.
Now, who was present at the time that you saw Ms. Clearman going through Mr. Clearman's pocket?
It was me, the victim, and the wife.
Now, did you talk to a detective after seeing what you saw on that evening?
Yes.
And what information did the detective ask you about based off of what you kind of witnessed or experienced on September 22nd?
I believe he just asked me, like, what did I observe, what happened, and then if I had any more questions or concerns that I could contact them.
Okay.
And that was it.
So at the time that the detective, you know, kind of expressed that to you, did you provide him this information?
Yes.
Okay. And you also indicate that, okay, so what happened? So after you talked to the detective, that was the detective on the scene, is that correct? Or?
I believe so.
Okay. All right. And did you get his name?
No, I did not.
Okay. And you end up, what happened later on that evening? Did you just go home, or what took place after leaving the scene?
Well, I went home. I started getting my children ready for bed. The detective called. I spoke with him. And then, like, later on that night, it was just kind of bothering me what I have observed. So I decided to call the homicide unit.
I want to stop for a second, Ms. Trotter. You said something was bothering you. Can you explain what that something was to the members of the jury?
It was the wife's demeanor. I mean, like, she wasn't consoling him. I don't know if that's the right word, but her bending down and going through the pocket was kind of suspicious and weird to me. So that kind of stuck with me.
Okay. And did you communicate that to a detective later that evening?
Yes, I did.
And how did you communicate that information to a detective?
I called the homicide unit.
And how did you get in contact with the homicide unit?
I called them on my own. I got the number and I called.
Can you tell the members of the jury approximately what time you called the homicide unit that evening?
It could have been anywhere from 10:30 that night to after 11.
So within a couple hours.
And what was the homicide unit's response?
I know what
to
she's
you
getting
provided
at
this
there, that
information
she
to?
didn't comfort her dead husband.
So I called the homicide unit and I kind of explained to the person that answered, you know, who I was and why I was calling. And they told me to hold on. And another guy got on the phone. He described himself, but I didn't. I'm sorry, which part do you need? Okay, so I called the homicide unit. A person answered. I spoke with him and kind of told him why I was calling, and they told me to hold on for a second. Then another person got on the phone. He said, this is whatever he said his name was, and I explained to him the situation again, what I had observed and where it was at and why I was calling.
And Ms. Trotter, can you explain to the members of the jury what was his response?
He said, thank you for the information. Have a good night. Or something to that nature.
Ms. Trotter, did anyone from the Milwaukee Police Department at all ever follow up with you in regards to the statements that you made on that evening?
Never.
Ms. Trotter, it's almost a year and a half later. Has the state ever contacted you regarding any statements or any observations that you made regarding...
Objection, Your Honor. Relevance.
Sustained. It's a police investigation.
Ms. Trotter, has anyone solicited your statements or your testimony today? Has the defense counsel ever contacted you to...
Objection, Your Honor. Relevance.
It's also vague. Sustained. Anyone? Counsel, you said, has anyone done that?
Ms. Trotter, has anyone representing Mr. Edgecomb, myself, Anika Ahmad, has either of us solicited your statements today for the testimony that you provided?
Objection.
No.
I'd overrule that.
Ms. Trotter.
It was answered, but let's move on. And
Ms.
You
Trotter,
got
can
your
you
question, and we know
explain
what you're going at.
how did you come to provide this information relevant to this case today?
Objection, Your Honor. Relevance.
And it's been asked and answered. She's already explained the whole thing. Sustained. Move on.
Ms. Trotter, I'm showing you now what has been marked as Defense Exhibit number 29. Ms. Trotter, do you recognize that?
Yes.
What do you recognize that to be?
This is the area that I approached the night that I seen Miss Clearman in distress.
Now publishing what has been marked as Defense 29. We give state access. Access to the media on the state side.
Oh, Judge, you gotta flip over evidence control.
And then also, while we're doing that, I also want to show you, Ms. Trotter. Does this appear to be the end part of that same area?
Yes.
So, Ms. Trotter, is this what you just testified to as the area that you encountered Mrs. Clearman, the deceased in this case, Mr. Jason Clearman, on September 22nd, 2020?
Yes.
Move myself out of the way.
And is this the entrance area to that same area in which you encountered Mr. and Mrs. Clearman on that evening?
Yes.
That is a nice, tightly confined space, guys. That's another factor if you want to claim. It was dark, it was scary, the stairs were there. I had nowhere to run. I couldn't hop the fence.
No further questions. Thank you.
Great. Thank you. Cross.
One moment.
I'm not sure he's going to have a ton of cross for her.
How you doing today, ma'am?
How you doing?
So I just got a couple questions for you. I'm just going to go through it here in terms of what you saw that night. You didn't see the incident, did you?
No, I did not.
You didn't see who the shooter was?
No, I did not.
You didn't see anything regarding the altercation at issue between the man who shot the victim and what happened between those two people?
No, I did not.
Okay. And then, just to be very clear, you stated that when you were talking about Mrs. Clearman and she's by her husband's body, you stated she couldn't get into the pocket, correct?
No, she could not.
You never saw her take anything out, right?
No, I did not.
Never saw her put anything in?
No, I did not.
Never saw anything in her hand?
Oh, hold on.
I apologize for getting too quickly. I was on a roll.
Yeah.
Got to slow down, boss.
Take your time, please.
Yeah, I'm sorry. I had way too many Diet Cokes. Now, just so we're clear, ma'am, you never saw anything in her hands, right?
Nothing but her cell phone.
So, whatever she was doing, doesn't appear that she actually handled anything, right?
She was
You never
trying
saw
to
her
get to
handle
the
it.
knife.
I
though.
never saw her handle anything.
Never
I
saw her
didn't-
take anything from anywhere else or move anything else. Is that correct?
That's correct.
Okay. Now, what you just talked about, you stated you later called a homicide detective.
Yes, I did.
Did you mention it during the 911 call?
No, I didn't. That's why I called the homicide unit.
Understood. My question is, did you mention it during the 911 call?
No, I did not.
Okay. And I've got your 911 call here. I'm just going to play it here for a little bit. Let's play, in your honor, for the record. This is State's Exhibit number 39. This is the 911 call. And I'm going to play it here in the beginning and tell me if you recognize it, okay?
Okay.
All right. I'm going to play from the ooh, I'm going to need to get a little bit more volume there. Play from 1 second in the recording. Of course, it's not working now. Pausing in 9 seconds. Do you recognize that voice?
Yes, I do.
That's you, right?
That's me.
Okay. And playing from 9 seconds into that recording.
He's talking dead in the head, on the bridge. His wife is here.
All right, repeat that intersection.
We on Brady and Houston, I believe it is. It's like a place called College. You might agree on Brady and Houston.
Down the line, I'm going to connect you to the medical help and I'll hang up. Did you see the person that did this?
No, his wife is here. She seen everything. Hey, Houston. I think it's Houston.
Milwaukee Fire Department, where is the emergency?
Hi, operator 51, the intersection of Brady and Holton, a man was shot in the head.
Thank you, police caller. This is the fire department. We're already en route now. Are you with the patient?
Yes, his wife is here. She is very hysterical, and he is here.
Oh.
Okay, pausing in 1 minute and 2 seconds. You stated that his wife is there. She's hysterical, right?
Correct.
Okay. So, just so we're talking about, how you saw her reacting in the moments after her husband's been shot in the head. She's hysterical.
Correct.
I mean, did it appear she'd been traumatized?
You could say that.
Okay. I mean, she's consistent with having just seen someone she's married to shot in front of her eyes, correct?
At that time, yes.
Okay. Now, I'm going to play from that moment at 1 minute and 2 seconds.
Okay, are you with him?
She's with him. Yes, I'm feeling like away.
Okay, can you tell if he's awake or breathing or anything?
She was just trying to talk to him, but I don't think he responded.
So, he asks you about information about whether or not the person's alive or dead, right?
Correct.
And you stated she was trying to talk to him, right?
Yes.
Just so you're saying that you previously testified that it appeared she didn't seem to really care, but here you have her talking to him, asking him, right?
Well,
is that what we just heard?
Yes, but
okay,
not,
thank you.
Yes.
Now, in terms,
And this is cross.
It's cross. You can
You'll
shut
get
the
a chance
witness
to
up.
follow up.
now, she's
This is the mark.
Knock off the insulting behavior towards the court. Knock it off.
The judge says you don't.
Your Honor. Now, ma'am, she's talking. She's trying to address her dead husband. He's not responding. He's gone, right?
Man, if the judge says something you don't
she
like,
was
that's it.
responding
Move
to
on. You
whoever
don't
was
react.
on the phone with her, and she was saying,
Can't act with an
Ma'am, that's
attitude.
not what we just heard on the 911 call, is it?
well, I mean, it was different.
Ma'am, that's not what we just heard on the
That's not what you heard on the 911 call, but I was present.
I get that. So
Okay.
when you're on the 911 call and they're asking you for up-to-date information, and they say, are you with them? And you tell them she's talking to him and he's not responding, right?
Correct.
Okay. Now, playing from that portion at 1 minute and 12 seconds.
He said he was trying to hit, point blank.
Okay. So are you close enough or
Is he breathing? She said, no, she's sure he's dead.
You just asked, is he breathing? And she says, no, he's dead, right?
Correct.
Okay. Playing from that portion at 1 minute and 22 seconds into the recording.
Okay, did she say she give me out? Because we can give him CPR. He's not breathing.
He said he's breathing. He said CPR. He said he's trying to. She said she don't think so.
Okay, the fire department is already on the way. Ma'am, finish with the police.
Okay, ma'am, did you say you didn't see who did this?
No, I didn't see it, but she was here. His wife did. She said his name. She said he was on a bicycle.
He was on a bicycle?
She said the guy that shot him was on a bike.
And what direction
did he go in? You don't know? No, I didn't see that. I just seen, well, I was riding past, and I seen her just, very hysterical running back and forth, so I had pulled over and stuff, and she started telling me what happened. So I just called 911, so I don't know.
Now, you stated you pulled over, asked her what happened, and you called 911. Is that correct?
That is correct.
Okay. Now, Your Honor, the state would move that portion of State's Exhibit number 39 in evidence.
Received.
All right. Now, moving on to State's Exhibit number 83, do you remember getting a phone call from an officer that night?
I do.
Okay. An officer actually called you that night, didn't he?
That's correct.
Okay. And you talked to him about what you saw. Isn't that correct?
Yes.
Okay. Get to 6 minutes and 3 seconds. Your Honor, the state we're going back to what's previously been played as Officer Nebraska's body cam, but we're going now forward to 6 minutes and 3 seconds into the recording. Ma'am, playing from that
Hang on. What exhibit is this?
Oh, State's Exhibit number 83.
83. Fine.
Officer Nebraska's recording 2. We previously played an earlier portion from this with a different witness. We've now moved up to 6 minutes and 3 seconds into the recording. I'm going to play from this portion, ma'am. Hopefully I've got the timing right.
Okay.
Hi, this is Officer Nebraska with the Milwaukee Police Department.
Actually, I'm going to go back just a little bit because I didn't time it right. I apologize, ma'am.
Okay.
5 minutes and 58 seconds into the recording.
Hi, is this Stephanie? Hi, this is Officer Nebraska with the Milwaukee Police Department.
Pausing at 6 minutes and 7 seconds. Is that you?
I'm Stephanie Trotter, yes.
So that was you on the phone that this officer is calling. Is that correct?
Correct.
You recognize your voice?
Yes, I do.
Okay. I'm going to play from that portion at 6 minutes and 7 seconds into the recording.
You called about some shots fired over by Brady and Van Buren earlier? Okay. Has anybody talked to you yet about this, or? No. Okay.
Pausing at 6 minutes and 26 seconds. If I'm not mistaken, with defense counsel, you had stated that you had stayed on scene and spoke to a detective. Is that correct?
That's not correct.
Oh, then maybe I misunderstood. This is the first time anybody talks to you. Is that correct?
That's correct.
Okay. So you didn't remain on scene, did you?
When the fire department came, I left.
You left. Okay. I totally misunderstood. I thought that they were trying to say he's talked to a detective on the scene. You went home, didn't you?
Correct.
You didn't stay on the scene.
No, I did not.
So this is the first time an officer actually calls you, and he's following up. Like, hey, we got you as a 911 call. I want to talk to you about what happened. Isn't that correct?
That's correct.
Okay. Sorry about that. I totally misunderstood his question earlier. Now, going to 6 minutes and 27 seconds into the recording, I'm going to play from that portion, ma'am.
Okay.
You mind if I ask you some questions? Sure. Can I start by getting your information, ma'am? What's your...
Now, they get down your information. Is that correct?
That's correct.
I'm not going to put all your personal information out
Thank
there.
you.
No problem. Don't need to do that. But let me just move forward just a little bit, okay?
Okay.
Moving forward to, I think it's 6 minutes and 55 seconds if my horrible notes are right. Let me just play from this portion. I wasn't right. Let me move forward a little bit more, ma'am. I'm sorry. 7 minutes and 2 seconds.
And this phone number that I called, is this the best way to contact you? Okay. You said you were driving by and a female flagged you down for this?
She was like, you could tell something was wrong when we was riding past. I seen her like waving and running back like where his body was laying at. So I immediately ended up pulling over, and when I pulled over, I could see his leg once I had got out of hand. I'm like, is everything okay? She's like, no, somebody just shot my fucking husband in his head. So I'm standing there, and she's like, can you please call 911? She's like, I'm sorry. She was just shaking me back, so I called 911, and somebody else must have seen what was.
Now, ma'am, You're talking to Officer Nebraska right there, is that correct?
That's correct.
And you're talking about the manner in which you came to call 911, is that correct?
That is correct.
And you basically just stated that she was too shaken to call 911, so you called for her, correct?
I asked her, has she called 911? She said no, so I called, yes.
She's hysterical, correct?
She is.
And you're talking to Officer Nebraska about the manner in which you called 911. You ask her if she called 911, she's hysterical, she asks you to call 911, and you do for her, right?
That is correct.
Okay. So, when you're, that night, when you're talking to the officers, fresh in your memory, fresh as to what happened, you're telling the officer that the reason you called 911 was because she was too upset and she asked you to call 911 for her.
That is correct.
Okay. Playing from 7 minutes and 42 seconds into the recording.
Yes, this judge hates the world.
Do it a little better here. And then, did you just mention that there was another guy on 911 talking to 911?
It was.
So there was another guy.
He was standing directly across the street from where we were.
Okay, so there was another guy that you saw across the street also talking to 911.
That is correct.
Okay. Don't know who he was.
I don't know who he was.
Okay, so previously when we were talking with defense counsel about who was around the body when you're talking to 911, body was there, Mrs. Clearman was there, you were there, your husband's in the car, and there's another 911 caller across the street.
Yes.
Okay. All right. Playing from 7 minutes and 58 seconds.
She's very hysterical. I was just letting her know that they said the ambulance was on the way, and I seen the ambulance coming, so I left because I had my kids in the car. Okay.
And you had your kids in the car, right?
That is correct.
And she was hysterical, correct?
She was scared. She was.
And you were just trying to get her help, right?
That's correct.
And that's why you called 911.
That is correct.
And I just want to to be clear in regards to what we're describing. When you're talking to this officer and he's asking you about what you saw, about with the wife, and what you saw about it, you don't mention anything about her being by the body and kind of somewhere around his pants, do you?
At that time, no.
You didn't mention it?
No, I did not.
Okay. And also, even what you're testifying here today, you saw her down by the pants. You never actually saw an object come out or go in or go anywhere near his pants, did you?
I did not.
You don't know what she was doing, do you?
I don't know what she was doing, but no, I don't know what she was doing.
And she was hysterical, wasn't she?
Sustained. Was asked and answered.
Many times. I apologize. Thank you. I got no further questions, ma'am. And Your Honor, the state would move this portion that's been played in evidence at this time.
Fine. That portion only is received. Any follow-up?
Now, Ms. Trotter, you indicated that when you called 911, that you weren't in the vicinity of Ms. Clearman at the time. Is that correct?
That is correct. Wait a minute, rephrase that. Rephrase it.
You weren't in the direct vicinity of Ms. Clearman at the time that you were on the phone with 911, correct?
Yes, I was, you know how the opening is? I was standing like right outside of it, and she was to the far left of him.
Okay. So your testimony is that Ms. Clearman is by Mr. Clearman's body, and you're on the outside by the opening on the phone with 911, correct?
That is correct.
Ms. Trotter, were your eyes on Ms. Clearman the entirety of while you're on the phone with 911?
Yes, they were.
Okay. Now, when you indicated that you couldn't tell whether she received, whether she got something out the pocket or anything like that.
Judge, Your Honor, mischaracterization of the statement. She said she never saw anything. Not that she couldn't say what it was. She never saw anything.
That was my understanding, but you can clarify.
You can clarify, Ms.
I never saw anything.
Okay. So you don't know whether something was taken out, put in, or anything at the time.
Objection, Your Honor. Leading mischaracterization of the statement. She never saw anything.
Hang on. It was leading. It's your witness, counsel. Go ahead.
Can you confirm whether or not anything was taken out of the pants pocket or put inside the pants pocket?
Objection under speculation. Ask her if she saw anything. Confirming or not, this is speculation.
It's speculation. I think it's also been asked and answered. I'll let you ask it one more time, and then we're moving on.
Can you describe anything that you could confirm regarding the pocket as Ms. Clearman was next to it at the time? You're on the phone with 911.
Yes, honestly, I just thought it was weird that she was, you know, like, I don't want to say rambling, but like going towards his right pocket.
Now, Ms. Trotter, you indicated, I'm going to present again what's been marked as Defense 29. Now, do you remember, you indicated that you remember this area, correct?
That's correct.
And is this area appear, how would you describe the size of it? Small,
Objection
large,
there,
how would you
outside.
describe it?
This area is outside the scope of cross-examination.
Your Honor, she testified earlier about her knowledge of being there at that place where Mr. and Mr. Clearman was at the time.
She did during direct, but not during cross.
Overruled. Make it brief.
Go ahead.
What was the question?
Would you describe this area as being small or a confined area?
It's a small area.
Okay. And
just to clarify, we're talking about the exhibit. Is that what we're talking about?
yes, we're talking about the area where Mr. Clearman would have been laying at that time, correct?
It's a small area.
Okay. And did you have occasion to look at the stairs that go down to that area?
Yes.
And how would you describe those stairs that go down to that area? Were they steep?
Like steep.
Okay. No further questions, thank you.
Thank
Hey
you.
guys, everybody, let's take a chill pill. It's all good.
All right, you can step down, ma'am. Thank you.
29 into evidence.
Was that the photo that's up?
Correct.
Fine, received.
I think
thought it was
Theodore's
already,
next.
but received. All right, well, she's stepping out. Who's the defense next witness?
See his
We need to
reaction.
see who's out. We did send out a lot of subpoenas. One witness is sick, and we may need to have a substitute for them tomorrow morning. That's what the medical examiner
Guess
told
Theodore's
us.
not going till
But
tomorrow.
We did
Well,
subpoena.
take 2 minutes, step in the hallway, see if somebody's here. I want this to continue to move forward. Take a minute.
Yeah, guys, look, if somebody's unhappy, just let them be unhappy. There's no point engaging with them. I appreciate you guys standing up for me, but it's okay. Remember, this is just the internet. It's not serious. It's not for real. As far as other things, though, somebody mentioned ineffective assistance of counsel. No, these guys are far from ineffective under the ways a court would rule on that. Ineffective assistance, you have to meet a specific test the Supreme Court of the United States laid out, and that your conduct has to be so bad that had another attorney done what you didn't do, it would have had a substantial impact on the trial. So just being horrible at your job is not enough. There are cases where attorneys have fallen asleep in court, sitting right next to their defense attorney, nodding off and sawing logs. Nope, not ineffective. I mean, it's a very, very high bar to get. Now, it's always argued in court, and courts always shoot it down on appeal. So these guys are far from ineffective. In fact, many of the times where ineffective assistance is alleged, it's usually the attorney who doesn't ask any questions, just sits there. So these guys are far from it. They're incompetent, but that's not the same standard.
So, Judge, one of our witnesses is coming through security right now. The other witness is available, but there is an issue that has to be dealt with before. So we would just ask for a 5-minute recess.
All right, we'll take a 10-minute recess. Get my bailiffs lead the jury out.
Oh,
10 or
7 to
15
break.
minutes, leaving notepads where they are. Everybody else can remain seated, please.
Travis, the issue with the paralegals, that's done. The judge, she's back in the courtroom. I think that old mess is never going to come back up. So that's a past issue.
All right, the jury's out. Brief recess, 10 minutes off the record.
Funny lady, yeah. It's the standard for ineffective assistance of counsel is a case. Actually, see if I can bring it up and you guys can read along with me. Let me see if I can find something for us to hear. Okay, so this is the case. It's Strickland v. Washington. That's the Supreme Court citation. It's from 1984. This involves a death penalty case as well, so it's very interesting. So, what happened in Strickland is the defendant had committed some murders and he committed some robberies and he was charged with the death penalty. He ended up pleading out. And then for the penalty phase of his trial, he had told the judge, he had owned up to everything. And the judge still sentenced him to death. His argument was that had his attorney presented mitigating factors such as his mental health, his family's upbringing, all these different factors, the judge may have shown mercy and given him life without parole. So we went through the Florida court system. They denied all of it. He was set to be executed. And then the Supreme Court heard his case. And I'll show you what they argued eventually. Okay, so here's the nuts and bolts of it. It's not actually out of the opinion. This is kind of the condensed version of it, but it's also probably what you guys would actually want to see first. You can read the opinion later. It's very interesting. But you have to show that the counsel's performance was deficient. And number two, second part, that deficient performance prejudiced defendants so deprive them of a fair trial and give them a chance at a different outcome. So you have to get both those elements. And then as you can see, part B, the result of the proceeding would have been different. Now, you don't have to guarantee that it would have been different, but you pretty much have to show, had his first attorney not screwed it up, he would have had a decent chance of changing it around. But you have to consider everything that occurred. And it's a reasonable, like I said, it's a reasonable probability. It doesn't have to be 100%, but you have to show very likely this could have changed the outcome of the trial. So if evidence isn't shown, if a certain witness isn't called, you have to show that that witness or that evidence was critical. That, let's say, for example, they didn't bring anything up about the knife, but it turns out she actually did hide the knife. That would change the story a lot, and you'd have to show why it's important. So, once again, these guys may be committing malpractice, and I don't know necessarily that you could sue them for malpractice at this point. They just suck. And once again, if you suck at your job, it's like if you hire a mechanic or a handyman and they do kind of a subpar job, they screw things up, you might not be able to sue them, but you have to live with their crappy results. And that's the problem. Except with a subpar handyman, your house looks like crap. A subpar lawyer, you go to prison. So it's not exactly the same thing, but it's kind of how it goes. Ultimately, though, and you guys are probably wondering what happened in Strickland, well, the court didn't think his attorney was unreasonable or deficient, and that evidence wouldn't have changed the outcome, so they did not overturn his conviction or death sentence, and 2 months later he was executed in Florida. And I think back in '84 they still used the electric chair, so he got to meet old Sparky pretty quickly afterwards. Travis, he's not charged with premeditated murder specifically. It's just intentional murder. Um, Intent is not something you have to sit and plot and plan for. You can establish intent very quickly, and it's clear he intended to murder him. If you shoot somebody in the face, you've made it clear your intent is to kill them. So the fact that he may survive is not really something you can attribute to. It's more than just luck. So it's clear he intended to kill him. I don't think that's an issue at all. More importantly, if it was reckless homicide, I think his arguments of self-defense don't work because you can't recklessly assert self-defense. You have to intentionally assert self-defense. I have to intend to stop the bad man trying to hurt me. Does that help, Little Miss? Zoom in a bit more. Catherine, I think the putting the widow on blast for not doing that is they're trying to show she was more worried about sanitizing the crime scene. Um, as I said, these attorneys, they came up with a theory, and I've done this before myself. Before I have all the evidence, I've come up with a theory. Oh God, I got a smoking way to get my client out of this. And then you get evidence to the contrary, and then you have to plan around it. These guys haven't done that. I mean, they have their initial theory of the case, and they're just boring in on it like a laser beam, and that's causing problems because their reality is not matching the reality around them, so they look like lunatics. They look like liars. That's what's giving them all these problems. Oh yeah, Travis, intent even for premeditated murder. So when somebody gets those charges, the jury instructions, intent can be established right away. You don't have to. They clearly state that intent can be in the blink of an eye. Because think about it, you can make a decision that fast. Uh, GPS JC, what link are you talking about? Are you talking about this court case? You're taking the bar next Wednesday, Sauce Man? Oof. Good luck. I remember taking the bar myself. That was, only 7 years ago for me. Actually 8. Right now about 8 years ago. I took it in February of 2014. It's an experience. You won't forget it. Just remember, don't worry about studying right as soon as you get there. You either know it or you don't. Don't stay up all night studying in the hotel. Don't try to cram right before you go in. If you don't know it by then, you don't know it. You'll be a lot better off. Just being able to sit there, watch TV on your night off, go sit in the hotel bar, hotel restaurant, you will feel 100 times better than if you sit and study. Well, guys, if we're gonna, I need to take a bathroom break real quick. Real quick, I'll answer this. Amanda, I've been an attorney for 8 years. I was a prosecutor for 2 years, and for the rest of that time, I pretty much have done defense work. So give me 1 second, guys. Oh, Little Miss, what made me do defense work? I don't know. I've always been kind of drawn to the criminal stuff, pretty much, and I've done other things. For a couple of months, I did work doing stuff for oil and gas companies straight out of law school, like immediately after passing the bar for about 4 months. Just wasn't my thing, working in a corporate environment. And, I've also, when I worked as a defense attorney, I really liked it. And I thought I could make an effort and change the world being a prosecutor. And I did that for a while, and it's not really my place. I disagree with a lot of times how things are getting prosecuted, how things go, and you're not really making the world a better place there. I know some people might think that, and they probably do. It just wasn't for me. So I felt like I was more useful on the defense side of things. So, Little Miss, I'll say it like this. The idea of like going to law school and becoming rich, the rich attorney is kind of like it's probably like 35, 40 years out of date now. I do okay. Would I like to be doing better than I am? Sure, and this year I have some goals and some plans to try to push harder. I'm not gonna lie, part of me doing this is a way for me, I think, to work on things. But also, I'm not gonna lie, I hope this turns into an advertising tool at some point. Maybe I can land somebody in Ohio who wants to hire me for something or consult with me. So part of this is that. But I'm not driving a Maserati or a BMW. I certainly would like to be at some point. And for a majority of attorneys, you're not. It's not champagne wishes and caviar dreams. The top quarter of attorneys make $250,000 or more. So it's It's an okay living, but it's not the splashy and dashy I'd like it to be, and certainly maybe it will for me at some point. But for right now, I'm doing okay. Yeah, that puppy is being a little mouthy today. I had my office closed for a reason. Sauce man, I think there is something to be said about prioritizing it, but in criminal defense, it's harder because you're primarily dealing with people who don't have the money. I mean, most of the people who get in criminal trouble don't, and that's a bit different. My practice every year, though, year to date, has been getting bigger and bigger as far as just being able to do criminal work. So I think it's something you can get to, but it's a lot longer road than if you did personal injury or divorces or estate work. It's a harder road to get there, but it can be done. Yes, that dog barking was a Papillon. You know, Alex, I know you just brought that up, but I see other people. Um, Cheryl, they're sweet, but it's hard to talk while they're going. Uh, so, Alex, and I know everybody keeps on saying there's issues with the judge being biased. He's not being biased. If I went in there acting like that, I'd expect that judge to be crawling up my ass too. Um, if I was the judge, I don't. I mean, I would have done it differently, but I would be very at my wits' end and my patience with these guys, regardless of that motion they filed claiming the judge is racist. You've got to have your shit together. I mean, I'm not joking. Like, that's a very serious thing. You have to be ready to go, and they're not. These guys, it's not only that, but now we're starting to see these guys are having issues with basic stuff. Taking down, doing direct and cross, setting foundation for evidence, arguing objections, handling themselves in the courtroom. Like, you should know how to handle the technology in the courtroom before you're in trial. There should be like a dry run for that. But these guys aren't doing that. It's a lot of things coupled together. That's the reason why the judge is upset with them. I mean, those parts alone, I wouldn't want to be those guys. I'll tell you that much. Well, Travis, as far as the prosecution rehandling some of the videos, if they've already got them and it's in their custody and it's their exhibits, there's a bit of an understanding you're going to have to help out the other side, especially if you're the one in control. And sometimes there's only one control point, and that might be on the prosecution side. So if they just fired up an exhibit, yeah, then they still got it going. It's kind of common courtesy for them to run it. Same thing with defense. Oh, well, congratulations, little miss, on winning your case. It's not easy to do it by yourself, but it can be done. Like I said, funny lady, it's not a good way to set the stage for the trial when you're messing around and the judge is getting pissed off at you. It doesn't help. And I mentioned in one of my videos, when it comes down to, let's say there's an objection and it's really close, it could go either way. You know, you don't want the guy who's making that decision to not like you or think you're a turd. You know, every little bit of things you can do in your favor, you should be striving for. And pissing him off makes it more likely he's going to side with the prosecutor instead of you, or vice versa. And that's pretty civil for a judge. I've kind of like Inglourious Bastards, you know, that's not a chewing out. I've been chewed out before. I know what those are like, and yeah, I've been called to the carpet before in front of a judge. Wasn't intentional. Well, yeah, it was intentional. I kind of pushed my luck, but this isn't that bad yet. This doesn't happen all the time, but this is still not the worst thing that could have happened. Well, Binger in his interviews, he already knew he could push Judge Schroeder's buttons, so that wasn't really an issue of him getting a judge mad. That Judge Schroeder talks a lot of shit and doesn't do anything. He's all bark and no bite. So Binger was playing around knowing what he could do. Sorry, I was looking at my window. We're getting clobbered with snow right now. Violet, I don't necessarily think he's got a specific history with these attorneys. It's just on this case, and they've been horrible on this case. Stacy, yeah, they did ask for him to be recused because of his racial bias. They didn't. That wasn't a good idea. You guys got any other questions? I know it's a couple more minutes till we start. Hope I answered a bunch of them that you guys had while we were waiting. So at this point, it sounds like Theodore is going to testify tomorrow morning. I really wish I was available for that, but I don't think I'm going to be able to be. I've got court in the morning. I've got court pretty much all day, so sorry guys, I think you're going to have to stream with somebody else, although I may just turn the live stream on and just leave it on for as long as it'll run. I just won't be here. You know, Cheryl, I'm thinking about it. What I'll do tomorrow morning is I will fire it up, but I'm going to have to leave as soon as it starts. And then once it starts, I won't be here. I'll have the camera turned off, and you guys will just watch the stream silently and just amongst yourselves because I will be in court pretty much all day tomorrow. I was looking at my schedule and shooting some emails around, so yeah, I'm kind of stuck with my schedule. Catherine Fell, do I think there will be an acquittal? It's certainly possible. But as this goes on, the percentage gets
Mr.
lower
Mott,
and lower.
who's your next witness or witnesses, and what do we need to discuss?
Yeah, so
Judge,
I'll leave the stream on.
Our next witness we expect to be Ricky Burns. He is outside.
And what do we need to discuss?
Regarding John Black, there were two issues. One was, I guess we can deal with it after Mr. Burns, though. Mr. Black is also outside.
Mr. Hubner, any objection to that?
Well, I mean, can we deal with it now so we can just go back to back?
Makes
rather
sense to
than
me.
Take another break.
Well, how long do you expect Mr. Burns to be?
Stacy, I'm gonna have to figure out how to do those alerts
Yeah,
and stuff because
half-hour
I don't know
judge.
YouTube that good yet, and on this side of it.
Fine, let's bring the jury in. Let's have Mr. Burns take the stand, please. After him and Mr. Black, who else?
Yeah,
do you
funny
have?
lady, they did have a
Whether
motion
it's
for him
today
to
or
be
tomorrow morning.
recused.
We do have the toxicologist. We've also subpoenaed Dr. Kelly for a very brief testimony. We've resubpoenaed Detective.
Counsel, use the mic, please.
Sure, sorry, Judge. Detective Klabundi, the toxicologist, and what do you mean?
They're gonna recall the lead detective.
Okay, guys, let's not chit-chat amongst ourselves, Mr. Ahmad. So tell me who you're planning the rest of the day, today or tomorrow morning, please.
Judge, we do expect to conclude tomorrow morning. Mr. Edgecomb also would testify likely tomorrow morning. And there's one more officer that we have subpoenaed here.
This is a lot of people to get in a day and a
if
half.
Detective Klabundi is not available, then I may need to have Detective Kirkvold. He is here? Okay, he can probably stay.
So 2 or 3 more witnesses, and then the defendant, presumably. Is that correct?
Yes, we expect that tomorrow morning.
Fine. All right, so have the witness come in.
Judge, there was one record we have to make before Mr. Edgecomb decides to take the stand on the number of priors. That issue is still on the table.
Right. We can address that tomorrow. Let's have the next witness on the stand, and then if we need to take a short break to deal with the testimony from
Thank
Mr.
you, Andrina.
Black
I'll
or
keep that. I'll look
Dr.
into
Black,
that.
we can do that.
Also, before the defendant testifies, in addition to his record, we still need the court's ruling on whether or not the state is allowed to cross-examine. Yeah, sorry. They keep moving. Whether or not the state is allowed to cross-examine the defendant on that one sentence that was stated down in Kentucky about when the detectives say they're here from Milwaukee Police Department and want to speak about what happened in Milwaukee.
Remind me again, I'm not ruling on it now, but what was the one sentence?
Basically, the detectives sit down, speak with the defendant, identify themselves as Milwaukee police detectives who want to speak to him about what happened in Milwaukee, and the defendant states what happened in Milwaukee. I believe that that would be relevant in terms of the fact that, A, it's not a question, but B, if the defendant is going to be testifying that he's acting in self-defense, the fact that when 2 detectives come down and tell him that they want to talk to him about... Yeah, I'm trying. When the detectives sit there and say that they want to talk to him about what happened in Milwaukee and he feigns ignorance as to any incident, I think that is appropriate for cross-examination. And the court has not ruled on that yet.
All right, potentially. We'll discuss that tomorrow morning. Let's get the witness in here. We'll have the jury come in. We'll get the next
Real
witness
quick,
testimony done, and then we'll go from there.
GPSJC. Yeah, I've had cases where I know they're 100% guilty. I mean, I know it. I looked at, yeah, that's video, that's him. You know, that's not uncommon. I mean, there's a ton of it. Now, you mean where they admit it to me and then I have to figure out what to do? That's a different story and probably a, different video for a different day. I've also had a couple of cases where I was convinced 100% my clients were innocent. And those are some of the scariest ones. Scariest trials I've ever had. Travis, that guy was a material witness. They claim he wasn't going to show up, but he said he would. But because of being a material witness, they can have him in custody till he testifies. So, yeah, that's it. They just didn't think he was going to show up, so they forced him to show up. Donna Q, I cannot comment on that because of YouTube's rules regarding
Yes, the
the
jury's
virus of
coming in.
unknown origin.
Remain seated, please.
Also, it's 4:30 in Ohio, so I'm going to enjoy something.
All right, the jury's back. Sir, if you can stand and raise your right hand so you can be sworn in, please.
You solemnly swear the testimony you give in this matter will be the truth, the whole truth,
Naz,
and
what are you?
nothing but the
Which one
truth?
are you talking about?
Yes, I do.
Please be seated, state your full name, spelling first and last for the record.
Thank you. My name is Ricky, R-I-C-K-Y. Last name is B-U-R-E-M-S.
Good afternoon, Mr. Browns.
Good afternoon, sir.
How are you currently employed?
I'm an investigator in the Public Safety Office of a local college.
Okay. And I just want to kind of go back a little bit so that the members of the jury can have an understanding of your previous employment experience.
Yes, sir.
So if you can just kind of start back and just explain to the members of the jury, what was your, have you ever operated in law enforcement before?
Yes, from 1982 until 2014, I was a member of the Milwaukee Police Department. I have 8 years experience uniform patrol, 3 years experience plainclothes drug investigation, and 21 years experience as a detective, including 10 years experience as a homicide detective. I've investigated in the area of 1,000 homicides and probably a couple thousand shootings. The aspects of my investigation includes responding to incidents, conducting scene investigations, witness interviews, interrogations of suspects, location and inventorying evidence, and any other follow-up investigation that's deemed necessary in order to complete the investigation.
Okay. And Mr. Burns, as it relates, well, first, have you ever testified in court before as a part of any of the investigations or duties you had operating in that capacity?
Hundreds, if not thousands of times.
Okay. All right. Now, Mr. Burns, have you had occasion to look over some of the reports and some of the discovery as it relates to this case involving Mr. Edgecomb?
Yes, I have.
Mr. Burns, have you had occasion to look through reports involving how the Milwaukee Police Department handled certain parts of the investigation involved in this case?
Yes, I have.
Now, Mr. Burns, have you found any issue based off of the training or experience that you had operating in the capacity with the Milwaukee Police Department in this case?
Yes, I have found some issues in the investigation of this incident.
Okay. Well, Mr. Burns, if you will, I want to just kind of go one by one through some of the issues that you found involving the investigation in this case. Fair enough?
That is fair,
Are
sir.
they using him as like a critique detective?
So, Mr. Burns, let's start with the first issue that well, first of all, if you could explain to the members of the jury, what documents or information did you receive, videos, so forth, that you looked over to discover some of the issues that you found in this case?
I reviewed
This isn't going to go well.
Scene and the investigation reports filed by various officers in regards to this. I reviewed video from the scene and also some photographs from the scene. And additionally, I went to the scene myself, and the part of the scene I went to was the bridge where this actually happened, just to assess the area for myself, so I would have an idea.
And approximately how much time have you invested in looking over some of the issues or documents or information that's germane to this case?
10, 12 hours.
Okay. Now, Mr. Burns, let's start with the first issue that you've come to realize after reviewing information and discovery related to this case.
Well, I think the first issue I had was the investigation of the scene itself. And just understand that homicide investigations are probably considered the most serious investigations that a police department can respond to. And the procedure is that the uniformed officers respond initially. They assess it, and once they determine there's a homicide, they notify the detective bureau, and then the detectives come out to conduct a more detailed investigation. That's what detectives are trained for, to be more detailed in their investigations. There'll be one detective that is dedicated to the scene, and when I say the scene, they'll describe where the evidence is located, where the victim is located, anything that is concerned with that scene, any type of physical evidence. They'll describe that in their report. Additionally, they'll do a diagram indicating where each item was found. They'll take measurements. The measurements are detailed to the extent that if you read those reports 50 years into the future, you should be able to look at those reports and go back and reconstruct that scene based on the detail of that report. And one of the issues that I had is that you have the primary scene where the victim was killed, but then also you have secondary scenes, namely where the traffic incident happened and then where the punch occurred. And although those locations are described cursory in the investigation or in the reports, there should have been a measurement from each of those locations to the primary scene. And the scene where the traffic incident happened is not described at all. There's no address for that. And really, that's kind of how this whole thing started. So to not mention that, to me, is a major problem. Also,
Objection, Your Honor. Is this just a narrative? Can there be a question?
Right, it's a narrative. Let's make it a question and answer, please.
Now, specifically based off of, that initial observation, the failure to take, specific measures and so forth, how does that impact a potential homicide investigation?
because again, you're supposed to be able to refer to those reports and reconstruct the investigation into the future. If you have to testify in court, you should be able to refer to those reports to recall or describe exactly where everything was during the time of your investigation.
Now, I want you to talk a little bit about, once a homicide occurs, some of the duties of the first arriving officer.
Well, the initial arriving officers are, again, to assess the scene, and in this case, they determined that it was a homicide. First aid to the victim, if it's feasible. Securing the scene, and by securing the scene, I mean, usually you've seen the yellow tape. Usually that tape is put up to restrict access to the scene. They locate any witnesses, and if there are any witnesses there, they hold on to them for eventual interview by the detectives. They locate any evidence, and then when the detectives arrive, they brief them on their findings so that, again, the detectives can conduct a more detailed investigation.
Okay. Now, if the arriving officer comes to learn that an item was taken away from the scene or removed from the scene, what is the duty upon that first arriving officer at that point?
Well, if the arriving officer determines that something was taken from the scene, if they can retrieve that item, they should do so. And they should find out what was taken and why it was taken. And they should also inform the detectives or supervisor. But the point is to retrieve the item and find out who took it and why it was taken.
Okay. All right. Now, Mr. Burns, did you find that to have occurred in this investigation?
Yes.
Okay. Now, can you go to the next issue that you have come to realize as it relates to the investigation in this case?
Well, again, this goes to the scene. And reading that scene report, one of the major issues that I had was that this occurred on a bridge, and there was approximately a 20-foot drop. I went over there and I measured it. And, this is a major aspect because of the possibility of injury or death. And that drop was not even mentioned in the scene report.
And why is that issue? How does that come to be an issue as it relates to, a case that you could potentially have regarding it?
Well,
Well, I think it's vague, and I think the witness needs to clarify 20-foot drop from where to where, off of where. He said 20-foot drop. Let's clarify.
yes, sir. When I say 20-foot drop, you have the base of the bridge. You have the like the wall that leads to the sidewalk, and if you measure from the sidewalk to the bottom, the distance from the sidewalk to the bottom or to the ground is 20 feet.
And how does that impact a case when it comes to this point? How does that failure
20
affect
feet's a long way.
potential case?
Well,
Your Honor, I'm going to object to this because I believe this is going beyond the scope of what the court has allowed in terms of this testimony. I think it's getting into an area that's beyond that scope.
Yeah, it kind of
Answer
is.
this question, and we'll see where it goes.
well, just again, because of if someone is involved in a confrontation, there's the potential that someone could fall off that bridge and injure
Your Honor, I'm
themselves.
going to object. This goes specifically as to he's attempting to testify as to what people were thinking. The court has ruled that out.
Right. The witness cannot testify to what may have been going through the minds of either the defendant or the victim in this case or anyone else. Sustained. That last answer is stricken. Let's move on.
Mr. Burns, would that same risk apply to anyone, or is that irregardless to this case, or was there risk of an individual falling from the 20-foot relative to any investigation that the Milwaukee Police Department has, with that seeing where the incident occurs in that vicinity?
Objection, Your Honor, is to the relevance as to other investigations.
Sustained.
All right, Mr. Burns, what other issues did you find that took place in this?
Well, the interview of Mrs. Clearman, the officer or the detective who interviewed her described her as being hysterical at the time of the interview. And when you get a witness like that, you want to get as much information from them as you can. But if they are in such an emotional state, you want to go back the next day and re-interview them when they're more calm. And some of the issues that should have been addressed start at the bar where the Clearmans were before this occurred. I would have wanted to know.
Your Honor, is to the relevance as to what he would wanted to know.
Sustained. Let's ask another question, please.
Mr. Burns, could you testify to what the standard procedures would be, having learned that an individual was drinking at a bar?
The standard procedure would be to send a detective to the bar, interview the employees of the bar, find out
We got toxicology.
how
This
much
is not
the
relevant or
Clearmans had to
necessary.
drink, what their attitude or their disposition was when they left, a check for any video, because you want to determine whether they had, whether they would be affected by what they had to drink.
And did you find that to have occurred in this case?
No, no one ever went back to the bar to find out how much they had to drink, what their disposition was when they left the bar.
Guys, I'll
Now,
worry about the
had that
stuff
occurred,
later.
is there
I
normally some
appreciate
type
it,
of
though.
report or something that's normally documented in?
Yeah, if it had occurred, it should be in a report. If everything that an officer does during an investigation
He
should
answered
be.
the question. He's now
Hang
testifying.
on, hang on. What's the objection?
He's testifying in a narrative again. It's just paragraphs. I'd like it to be in response to a question, please.
Overruled, but let's just keep it moving, please.
You can continue.
No, it's just everything that an officer does in an investigation should be in a report, and it's well known in police procedure that if there's no report, then it didn't happen. And that's the way you approach these investigations.
Okay. And are there any other issues that you found in this case?
Well, again, back to Mrs. Clearman, there should have been a reenactment where she's taken to the location where the traffic incident happened, and you note that location, you get an address, then the location where the punch occurred, you note that location, you get an address, and then you take measurements from the distance from the traffic incident to the punch, the traffic incident to the shooting, and the punch to the shooting, so that you have a perspective of what occurred.
Okay. And did you find that to have occurred in this case?
No, I did not.
And how can that potentially affect an investigation or the understanding of what took place when you don't have that?
It gives you an idea of a spatial perspective, how far apart each incident was from each other, and in that spatial perspective, it also gives you a time perspective. How long would it take from the accident or the traffic incident to the punch, and then the shooting?
All right. Now, Mr. Berman, what is another issue that you found?
Well, again, back to Mrs. Clearman, I would have asked why they followed Mr. Edgecomb. What was their intention? Were they upset when they followed him? Why didn't they turn left?
No shit, they were upset.
Taking them home instead of turning right in pursuit of Mr. Edgecomb. Just to give you an idea what state of mind they were in, was there any conversation other than we should follow him? Was there any conversation as to, well, what are we going to do when we catch up with him?
And you didn't find
We
that
all
to have
know what was
occurred in
gonna
this
happen.
case, Mr. Berman?
No, not at all.
What other issues did you find?
Well, Mrs. Clearman went through her husband's pockets after
Objection,
this.
Your Honor.
Sustained.
You can.
Yes, they knew it.
What other issues did you find, Mr. Burns?
The report lists the locations of several video cameras that stretch over a couple of blocks, and some of the businesses were closed, but each camera that is listed in these reports, there should have been follow-up to go back to those locations to check any footage that was on those cameras in relation to this incident. And if there was no footage, then it should be noted that these cameras were checked, but there was no footage. But certainly, that is a major concern in this investigation, that those cameras were never checked.
Okay, so you're saying that there's a certain type of report that's normally filled out as it relates to seeing if potential camera footage is available?
Yes, it's just a supplementary report, the basic reports that was filed on every aspect of this investigation. An officer or detective should have been assigned that task, and they should have set about that task, and whatever results they got, they should have noted it in the report and made it part of the investigatory file.
So if an officer goes and looks for potential video and they don't find it, whose ultimate responsibility it is to ensure that and notate that actually has occurred and that it was thorough and impartial?
Well, in a homicide investigation, you have the initial investigation and involving the detectives and involving the officers. After that, there's a meeting or a briefing, and in that briefing you determine what has been done and what has not been done and what needs to be done. And everything that has not been done, probably a detective will be assigned to do something like those cameras, because it's such an important part of the investigation. And it will be the detective's job to check the footage, write the report, and make a supervisor aware that this follow-up has been done. And if it has not been done, a supervisor should be monitoring the progress on this assignment to ensure that it has been done. And sometimes an investigation or a follow-up like that will have to take course over a few days.
Okay.
But it has to be done.
Now, did you see that type of follow-up, as you described, take place over a course of a few days in this case?
No, I did not.
Okay. Now, Mr. Brown, are there other issues that you found as part of your review?
Well, I think one of the major issues that I found was that when you investigate these incidents, you have to be thorough and you have to be objective. You have to look at aspects of every aspect of the investigation. And one of the most troubling things that I saw was a witness was made available, and the detective involved just declined to interview that witness. And if I can just give an analogy, these investigations are like a jigsaw puzzle, and every aspect is a piece. And if one piece of that puzzle is missing, it affects the whole picture. So that's why you have to cover every aspect. You have to be very creative, very resourceful, cover every aspect of these investigations.
Now, as it relates to, we talked a little bit about video. Were you able to see any video evidence as it relates to the bar where the Clemens would have left from, as indicated in the report you reviewed?
No, there was no reports indicating that anyone had even gone back to the bar to interview witnesses.
Sustained.
Mr. Burham, any other issues that you noticed in this
Sorry about that.
investigation?
May I review my notes, please?
Yes.
Thank you. One issue, and again, this goes back to Mrs. Clearman. She's telling the detective that she and her husband have been at a bar, and then when they leave the bar, she almost hits a bicyclist, and during the investigation, there's an open intoxicant found in the rear of the Clearman's vehicle. And, as dark as this may sound, I would have given her an intoxilizer test to determine whether or not she was intoxicated or impaired.
Objection, Your Honor.
Sustained. I'm striking that. And let me see the lawyers.
Oh, yeah, that was kind of bad. Yeah, that was... Well, Sky, yeah, the objections are working out for the prosecutor, but it's because those are valid objections. Even as a defense attorney, I kind of have to say, those are fair. So this defense expert, I don't know if you guys have listened to this, but I think we all would have conducted an investigation in a similar way as he's described. So I don't really get what he's going to try to show here, but trying to go down the idea that Clearman's wife was drunk and that's relevant to anything here doesn't matter. If she accidentally ran him over, okay, then everybody gets upset. They have their fist fight and it's over. None of that then goes to having Theodore just say, oh, well, these people almost ran me over. They might try to kill me for real. That first accident
All right, I had a conversation
isn't
with the
really
lawyers.
going to go that
There's
far.
no evidence in this case that there was an open intoxicant in the vehicle. That can be clarified by defense counsel or the state on cross, but that answer is stricken. Based on the testimony thus far, no one has testified that there was a, quote, open intoxicant. There's been conversations about a can and something that was in the back door, the back
Yeah,
seat.
a can of White Claw.
Let's move on.
They're
That
going
answer
back
is
to it.
stricken. Next question.
Mr. Brown, after your full review of the investigation of files in this case, any other failures that you've noticed of the investigation in this case?
In regards to the knife in Mr. Clearman's pocket, I would have, I think a DNA sample should have been taken. I think a standard should have been taken from Mrs. Clearman in regards to any anything in the car that possibly affected this incident. DNA should have been taken from that too.
And why is that important?
Just to give you a full objective picture of what's going on.
And struck that. Is there anything else that you learned in reviewing?
Well, there were two witnesses who worked at a restaurant.
Like a dating site.
Gave
Holy
an account
shit.
of
You guys
this
are hilarious.
incident. I would have asked them if they had discussed this incident with each other or with anybody else, because sometimes witnesses can influence each other's accounts or statements. So I would have just asked them just to clarify that.
And you didn't see that question being asked as part of your review?
No, I did not.
Okay. Anything else that you found?
And another thing is that when you are getting witness accounts and they tell you what they saw, you want to see what their perspective. If they were across the street, you want to go to where they were and look towards the scene to see if they could actually see what they told you that they saw, just to make sure that their account is accurate.
And did you see that having occurred in this case?
No, I did not.
Anything else, Mr. Burrows?
No.
All right. Thank you for your testimony.
You're welcome.
Cross.
Did you review all the police reports?
Everything that was available to me, but I can
That
say
wasn't
that.
my question.
Hang on. One at a time.
Yeah, ooh, we got caught.
All the police reports.
All the police reports that were made available to me, I reviewed.
So if I'm understanding this, you are now testifying as to what constitutes a good or bad investigation only on what the defense gave you. Is that correct? Yes or no?
It's a yes or no.
Yes.
Ooh.
Okay. And in your opinion as to what should or should not have happened, did you ask him for any other reports?
No.
So you were willing to sit here and talk about what you just testified to and base your opinion only on what they cherry-picked for you. Is that correct?
No.
Oh, so you didn't ask anything more. You didn't ask if there was maybe a report or something else that maybe they didn't give you. Is that a yes or no? Did you ask for anything else?
No.
Okay. Did you watch the body cams in this video?
One of them.
One body cam.
Yes.
Who chose that body cam?
The defense.
The defense did. So, if we have a state's exhibit that has body cams from several officers going, to the scene, walking up, talking to video,
The
talking to
prosecutors had
people
it
at a
with this
door and
shit.
finding out that the Ring camera did not record, you never saw that, did you?
No, I did not.
You only saw one body cam that the defense asked you to take a look at. Is that correct?
That is correct.
Because that's the one they wanted you to talk about, right? You know what? I'll rephrase that question. You probably can't speculate as to their motives.
No, I can't.
I want to ask about your motives. Did you ever ask for any other body cam?
No, I did not.
Did you ever sit there and say, you know what? In order for me to truly determine whether or not these officers in a record-setting homicide year did everything, I want to watch all their body cam. Did you ever do that?
No, I did not.
Okay. You said you saw some of the photos. Did you look at all the scene photos?
I looked at what was made available to me.
So you don't even know if it's all the scene photos, do you?
No, I do not.
He must have scalped these guys for a couple grand.
I listened to one of them.
Was it again do you know there's 3 911 calls?
Yes, I do.
And you chose to listen to one?
Yes.
Because that's the one they chose for you, right?
Yes.
And they give you a 911 call. You don't ask any other questions, right?
That is correct.
Okay. So I just want to be very clear so that I'm understanding this. All of your opinions that you have just testified to have been based upon solely reports they chose, a body cam they chose, a 911 call that they chose, photos they chose, and not the entire investigation in this case. Am I right?
No, you're wrong.
I'm wrong.
Oh,
So
kill him.
you are basing your decision on the entire investigation without watching all the body cams?
That is correct.
Okay. So you feel that you can, based on what they cherry pick, still come to a conclusion as to the entire investigation?
Stop
Based
the
on
fight.
Reports, yes.
Okay, yes, based on the reports. For example, 830 West, 830, there was a ring camera. Do you remember that in the report?
I would have to review the reports.
Okay. And if the report doesn't mention this, but the body cam shows that the officers actually went there and found out that it didn't record, you'd be unaware of that, wouldn't you?
May I expound?
No, you may answer the question.
You'd be unaware of that, wouldn't you?
Mr. Hubner,
I apologize. Judge.
answer the question, sir. It's a yes or no question that requires a yes or no answer.
Yes, I would be unaware of that.
Okay. And if you were to watch the body cam, you didn't watch the body cam of Officer Manisha Howard, did you?
No, I did not.
You didn't see how Officer Manisha Howard sat there in Casablanca watching video backwards in an attempt to find all the possible segments of which the defendant is unseen?
No, I did not.
You didn't see how on the body cam she worked with the people at Casablanca who have access to cameras down Brady Street, and she watched to see if she could find anything?
No, I did not.
You didn't watch how after being at Casablanca, she gets into her car and goes the next block over to see if she can find any video that she could recover?
No, I did not.
Okay. And you didn't know that all of this happened the very next day, did you?
No, I did not.
Did you see the report where Detective Washington talks about receiving the Casablanca video from her and her partner?
No, I did not.
So when you're talking about how there should be reports about the ongoing next couple days where video is being withdrawn, you said you didn't see them. Here's a report you didn't see, right?
Which one are you referring to?
I'm talking about Detective Michael Washington's report, how the very next day after the homicide, two officers, or at least one officer, Officer Krause, went to Casablanca and obtained video. Did you see that report?
No, I did not.
So when you were testifying that you should have seen reports about people securing video later, is that because nobody showed you that one?
May I expound?
Is it because no one showed you that one? They're going to be able to get you to expound on all the stuff that they did later. I want to concentrate on this.
No, I didn't.
No, it's cross-examination. As you know, you've testified hundreds of times. It's a yes or no answer, yes or no.
Okay. All right. Just another thing. We're talking about this is a homicide investigation at the time. Officers and detectives had no idea who the suspect were at the time, that night, did they?
No.
And in fact, are you aware of how detectives spent a considerable amount of resources attempting to find the flight path of this defendant?
Yes, I am aware of that.
They went to Ratfinks. Did you see that? Finks? Did you see that bar video?
I didn't see the video, but I am.
The report?
I believe so.
Okay. What about across the street, Bel Air Cantina? Did you see that?
A report regarding that?
Yes.
I would have to
Okay.
look at the report.
And if this were officers and detectives following, going literally store by store, trying to find a possible escape route that this shooter had just taken, that would comply with looking for video, wouldn't it?
Yes or no?
Yeah.
No.
No, it would. So you don't believe looking for video where they're attempting to find the flight path of someone who just shot someone in the face is important?
It is important.
Okay, so they did that in this case, right?
Yes.
Okay, and then even a little bit beyond that, on the bike path on UWM, they went and found video there. Do you remember seeing that?
I believe so.
Okay, and then when the individual pops up on Locust Street, they found that video. Do you remember seeing that?
Yes.
Okay, and do you remember seeing how they developed and did a search warrant in an attempt to find this suspect?
Yes.
Okay, so detectives spent a significant amount of time attempting to find somebody who had just shot and killed someone in the street. Is that correct?
Yes, it is.
And are you aware of the fact, you're talking about interviewing of witnesses, did you see Rotrell Cameron's 911 call or the body cam of his interview?
I saw the report in regards to his 911 call.
Okay.
Stop the fight. It's over. It's over.
Speaks to
Stop the
officer over
fight.
phone.
Give the man some sympathy.
I believe I saw that report too. I would have to look again, but I believe I saw that.
Okay. And sometimes body cam can provide even a little bit more than what's in the report, right?
Absolutely.
For example, Rotrell Cameron told the officer that what he just saw was cold-blooded. That wasn't in the report, but was on the body cam, wasn't it?
I didn't see the body cam.
Okay. And you didn't ask to see the body cam?
No, I did not.
Because you only saw the body cam that they gave you.
Yes.
Okay. And to be clear, as we're going through the reports, the officers were told by Ms. Clearman that it had happened, this first swerving incident, had happened a block east or east of Casablanca. Is that correct?
That's one statement that she gave them, but there's also another one.
She stated to Detective Rodolfo Alvarado that it happened east, one block east of Casablanca. Isn't that correct?
That's one statement that she gave them, but there is another
that a yes
account.
or no?
No.
She did not say that to Detective Rodolfo Alvarado.
Yes, she did.
She did. And because you never watched Officer Howard's body cam or looked at Detective Washington's report, you're not aware of the extensive efforts that the officers spent on trying to find that on that block east of Casablanca, are you?
No, I'm not.
Okay. One moment, Judge.
Guys, this is awful expert testimony.
And sir, I want to make sure I have this correct here. You're testifying as to what you're saying is an incomplete investigation, based solely on what one party gave you, without asking for any additional information.
That's correct.
Never wanted to know if there was maybe a report they failed to give you, right?
No.
Never wanted to know if maybe they were holding something back from you that might affect whether or not you thought it was a good investigation?
No.
Never entered your mind?
No.
Not once?
No.
You know that there's tons of body cam, they give you one, never occurs to you to think, maybe I should watch the rest of it?
No.
You know there's multiple 911 calls, never occurs to you to think, man, maybe just for purposes of being thorough, like I'm accusing other people of not, I should listen to everything.
Objection asked and answered.
Yes
Object.
or no?
Yeah,
Object.
does it occur to
No.
you?
No.
Okay. Nothing else, thank you.
Defense.
That was brutal cross-examination. Good job.
Mr. Burns, the state just questioned you about your review of the file as it relates to body cam video, correct?
That's correct.
Is there a way to determine an opinion in the accuracy of an investigation outside of watching hundreds of hours of video?
Yes, there is.
Can you please explain to the members of the jury the other way that you can come to a conclusion based off of the sufficiency and adequacy of the investigation without having to watch hundreds of hours of body cam footage?
The reports, everything that happens in an investigation should be in the reports. And that was my primary source of information in regards to this incident, is reading the reports that were made available to me.
Reports provide a narrative but are not 100% accurate.
Police department.
Now, when you speak about reports, is one of those reports named like a supplemental report?
Yes.
Okay. I'm not showing you what is being marked as defense exhibit number D9. Yeah.
Denise, no, I don't think he's stoned. I think he's a fairly laid-back guy. I bet this is his normal demeanor. So it doesn't help him not look competent.
I want you to take a look at that and let us know, is that one of the documents you believe that the defense showed to you?
Yes.
Okay. And what does that report indicate?
Objection under hearsay.
Sustained.
Mr. Burrows, is your testimony that there was inadequate follow-up with specific locations, in this case, based off of a supplemental report such as what you have in your hand?
Yes.
This is also water, not vodka, in case you're wondering.
We would now like to move Defense Exhibit D9 into evidence.
Your Honor, objected to.
I'm not dealing with that now. We'll take it up outside the presence of the jury. For right now, denied.
Next question. Mr. Burrows, is there any other reports where they are summary in nature upon which you based your opinions today on?
Just the reports that were made available to me, and also the reports that were not written.
Now, Mr. Burrows, is it true that all critical information that's pertinent to a case is supposed to be inside of a narrative report?
That is correct.
And is the purpose of a narrative report to save time so that you don't have to look over voluminous information or footage?
The purpose of a narrative report is to describe everything that was done at a scene, and it should encompass everything that was done at a scene. So it's called a supplement report, and it should actually include everything that is pertinent to the investigation, even if it's in the video footage.
Now, Mr. Burrows, is one of the videos that you had occasion to see a poll cam that would be 1 minute and 34 seconds in length?
Yes.
Did you find any issues with the amount of video related to that poll cam video that was accessible?
Yes.
Objection, Your Honor. This is outside the scope.
It's outside the scope. Sustained. The answer is stricken. It's completely outside the scope.
Mr. Burrows, are officers trained to include all important details inside each report that they write?
Yes, they are.
And is there any exception to that rule based off the standard operating procedures of the Milwaukee Police Department?
There's no exception to that rule.
Thank you. No further questions.
State.
Just briefly, you stated your primary source of information in regards to this was the police reports, correct?
Yes.
Because everything should be in them, correct?
Yes.
And you never asked for all of them, correct?
That is correct.
Nothing else, thank you.
Yep, I saw that coming.
All right, the witness can step down.
Oof.
Thank you. All right, I need to send the jury out for a couple minutes, hopefully 5 or 10 minutes. It's 4:15. I hope to have you back in 5 or 10 minutes, and we'll go to a little before 5, and I'll let you know exactly how we're proceeding for the next half hour, and then also
Welcome
tomorrow.
back, Jackie.
So if you guys can take a short break, follow my bailiff out. Be back in 10 or 15 minutes.
Hey, Chloe, give me a minute and I'll talk about that just so you understand what's going on. The short answer, Chloe, is that this is what happens when your attorneys aren't doing their job properly and doing a very bad job. Theodore is going to testify, and it looks like it's going to be tomorrow at this point. There's only like an hour left that they're going to hold trial, so it won't be till tomorrow morning.
All right, the jury's out. Who's the defense? Next witness, and I think we may have to discuss the parameters of that testimony. Mr. Ahmad.
Judge, let me see if we have any other witness outside. Otherwise, yes, we do need to take up the issue with Dr. Black.
I drank a lot of Jack.
Fine, 5 minutes max.
Take a
Then I want the
Diet
lawyers in their seats in 5 minutes so we can proceed off the record.
I'm not drinking vodka, Granny, but I am drinking White Claws. What every growing boy needs. No, I said this, I'll probably say it again before the end of the night. I will not be here in the morning, I've got court, but I will set the stream up and have it set to record and stream out, so you guys can sit here and talk amongst yourselves. Just don't burn the place down while I'm gone. So, I think, Chloe, yes, American courts are a little different than courts in England, but no, if you're really kind of shit in the bed and having a bad day, yeah, this will happen. I mean, I've had judges write me like this before if I'm not doing the job right, but it's because they're not following the rules. They're not doing stuff you should know if you're coming in, especially on a murder trial. It's expected you know what's going on. If this was a breaking and entering or some low-level drug possession, and the attorney was inexperienced, the judge would kind of understand that and give a little bit of leeway. But this is a nationally televised event. This is a murder. This is as serious as it gets. So, no, he's not going to suffer fools at this point. Kimberly, he doesn't have to make up his mind because he's not the jury. The jury's going to decide the verdict. Yeah, Law and Crime isn't live streaming this because, well, more successful people out there than I am kind of stole their thunder, so they're being a little butthurt about it. So I had to scrounge around and find a stream myself. So as far as things are concerned, they're going to be in recess for about 10 minutes, it looks like, and then we'll come back and this will be an interesting evidentiary discussion. Hopefully I can fill you guys in as we go. Everybody who's liked and subscribed, thank you so much. I really appreciate, I appreciate it. It means a lot, believe it or not. I kind of thought I'd be out here talking into the wind. So thanks for your likes and thanks for your kind words. If you have questions, don't be afraid to put them down there. I don't mind if I've already answered it already. Marianne, Theodore can still decide not to testify, but he's going to have to because none of the evidence so far, none of the testimony really backs him up, so he's going to have to do it himself. Also, generally speaking, in a self-defense case, the jury's going to want to hear from you. That's one of the few times we're testifying in your defense. You should be prepared that that's going to have to happen. Now, like if there were other witnesses who could say, yeah, I saw a knife, I saw him do something, I heard him screaming and I'm going to kill you, you N-word, then yeah, he wouldn't have to testify, but nobody else has stated that so far. Nas, no, you don't let him testify early. You let him go last. Letting him go first, you're trying to lay the foundation, lay the narrative. Not everything was checked. You keep hammering on that. You don't finish on your weakest act. You finish on your strongest one. Yes, Shannon, I am an attorney. I'm an attorney in Cleveland, Ohio, and I practice primarily criminal defense work. Yes, Violet, his odds of acquittal, I think, are shrinking as the minutes go by, but it's kind of how it was going to go. Either he was going to hit this out of the park or, not have a chance. Uh, I mean, San, here's what I'll tell you. If you came and sat down in my office and said, hey, I just got indicted, here's what the indictment says, that's words on paper. It doesn't mean anything to me. For all I know, it's all made up. Now, once I get all the evidence and file for discovery, getting all the proof that the prosecutor has, I'll have to sit down with you and say, hey, look, here's what it looks like. And yeah, it looks like you did it. And then I'd have to talk about what your options are. But until I see proof otherwise, I presume nobody's done anything wrong. You could call me right now and say, hey, they're digging up my crawl space and they're going to find a 30 dead 3-year-olds buried underneath it. Will you defend me? And my job is to do what I can. My job is to represent you and help you put you in the best situation possible. Maybe that means you don't get the death penalty. Maybe that means I suppress all the evidence. I don't know. Maybe it's something in between. That's the goal. He's gonna have to testify. I don't really see a way around it. So his criminal record at this point doesn't matter. He's got to do it. That's part of the reason why not committing crimes is a good thing, because if you don't have crimes on your criminal record and you're forced to testify, you look like an even better person because you're law abiding. No, I don't. I don't feel bad about it, San. I've gotten people, not necessarily off, but they got convicted of something far less than what they did. So they served maybe like a year in prison for something they probably should have served 20 or 30 years for. But that's not my fault. The prosecutor has their job to do, and I have my job to do. As if you watch The Wire, as the great Omar says in there, it's all in the game. They have their game, I have mine. Oh, don't worry, Jackie. There is some cussing that'll happen, just not right now. I'll save that for later. Jackie Jones, he can appeal if he loses, and God forbid he does. But the problem with appeals are you've already lost your case. And now you're asking another court to overturn your conviction. That is very hard to do. You're getting into lottery ticket territory. And for the appeals that do get overturned and sent back down, it's usually for resentencing. Usually courts will go out of their way, an appeals court will go out of their way to say this was harmless error, meaning you would have still been convicted if this didn't happen. Yeah, Shannon, I don't blame him for running. I don't blame him for sitting there looking at the whole scene going, oh my God, nobody's going to believe me. Not only because he's black, but think about Kyle Rittenhouse. Kyle Rittenhouse had all of that proof that he committed self-defense, and they still charged him. So, can you fault him for wanting to run? I don't think you can. Yeah, Lil Miss, I don't think he'll win if he appeals. I mean, he'd have to. The evidentiary issues and the objections that are going on, none of it's. Judge has not ruled him properly. I don't think he's abused his authority. Andrina, don't worry. I hate to fill you in on this, but I might be a little disrespectful at times. And I might swear a lot, so but that comes in fits and spouts. Yes, Chloe, he's claiming self-defense.
On Edgecomb, who are
Oh,
the
here we go.
defense additional witnesses? Just in order, please.
Judge, so we have Mr. Edgecomb, we have Dr. Black, we have maybe a substitute witness from the medical examiner, which is very short. I imagine 5 or 10 minutes, and
Yep, we'll talk,
potentially
guys. We
Dr.
can talk.
Kelly also 5 or 10 minutes. Maybe one more officer, Detective Kirk Vold, to step in for Detective Klabundy.
Hang on, can you use the mic? I can't hear you.
Sorry, Judge. So I think we have a total of 5.
Your client, Dr.
5
Black,
more fucking witnesses?
an officer,
Jesus.
and who else?
Medical examiner or the toxicologist. We've subpoenaed them both. We did have contact with both of them. They are available tomorrow morning, and that would be very short. I do think we will wrap up. We'll be done before the lunch hour with our case. But we did, Judge, want to address some issues regarding Mr. Edgecomb's testimony, the number of priors, and a couple of other issues which we put on the record. I think if we could address that now, we can start right away, and I think it would make sense, given that it's 4:30, to let the jury go, and for us to just deal with all this until 5.
Is the state, based on what you know right now, anticipating any rebuttal?
Possibly. I don't know, but I did put on notice the possible rebuttal witnesses, and then there's actually more based on what the defense has provided. I don't know how many I'd use. I don't think it'd be more than 2 or 3. And I haven't, I'd have to wait to see. As it stands right now, no. But depending on what they bring in tomorrow, possibly.
Fine. All right, I'll bring the jury in. I'll discharge the jury. It's 4:30. We can discuss some of these issues. And I'm going to expect the defense to have all their witnesses lined up and ready to go at 8:30 tomorrow. If the state ends up with rebuttal, I'm going to expect the state to have the rebuttal witnesses ready to go promptly tomorrow. I'm going to tell the jury that we are going to finish certainly with testimony tomorrow and hopefully the entirety of the case. Deputy, you can bring him in a minute. So I'll discharge the jury with the thanks of the court and the parties, and then we can discuss a couple of the witness issues.
So they're going to kick the jury out, tell them to go home, and then start working on the problems they have. Theodore likes ginger ale.
All All right, welcome back, ladies and gentlemen. It's 4:30. Where we stand is this. The state, as you know, concluded their case subject to rebuttal this morning. The defense has been calling witnesses. The defense has a handful of other witnesses to call, approximately 4 additional witnesses. I am 100% confident that we will conclude testimony tomorrow and hopefully conclude the entire case and submit it to 12 of you for deliberations. But we will certainly conclude testimony and hopefully conclude testimony in the morning. The witnesses that are anticipated tomorrow, a couple of them are going to be very quick 5 or 10 minute witnesses. There'll be a couple of others that may be a bit longer. I need to discuss a couple things with the lawyers. You don't need to be involved at all, obviously, with what I'm going to discuss, but I need to discuss some things with the attorneys. So I'm going to excuse you for today a bit early. I'll stay for the next 15 to 20 minutes to discuss the things I need to discuss so that tomorrow the witnesses can move promptly along. Obviously, you've heard these directives and my warnings multiple times, but I'll say them again briefly. Please don't discuss this case. Don't do any deliberation. Again, that means don't, if 2 of you are on the elevator or 3 of you are at lunch tomorrow, don't discuss anything about the case amongst all of you or any of you, group of 2, group of 3. Again, don't do any research in this case. And very importantly, there has been and is ongoing media coverage of this matter. That includes some video coverage. It includes written coverage. Please avoid that. Please do not watch the local news tonight. If you see something in a newspaper, if you see an article, please don't read it. As I've said earlier, you need to ultimately make your decision and reach a verdict in this case based only on the evidence that's been presented during the trial. That means the witnesses, the exhibits, the videos, the things you've seen over the last number of days, and we'll probably finish up with seeing tomorrow. I appreciate all of your efforts. To my observation, you've been very patient, you've been attentive. I used to say 200, but by now it's probably 250 or 300 jury trials in my career. And I can tell when a jury's paying attention, and I can certainly tell that you've all been paying attention. So I appreciate that, and the parties appreciate that.
He says that to all
Please
of
be
them.
back tomorrow again, 8:15 or 8:20.
He knows they
I'll try to
checked out.
start again as close to 8:30 as possible. I think that's it. If you have any questions, let my bailiff know on the way out. Follow my bailiff out. We'll see you tomorrow morning. Thank you, everybody. Everybody else can remain seated, please, while the jury is out.
So, M, you were asking how much would a trial like this cost? I mean, a minimum of 50 grand and on up. I mean, Kyle Rittenhouse's trial, Jesus, I can't imagine how much that cost. Oh, you gotta be kidding me. They're not gonna show it. Oh, damn it.
Safe.
Well, I guess that's it, guys. It sucks we're not going to see what's going on here, but yeah, and like I said, a jury trial for a homicide case easily starts you out at like 50 grand, and that's at the bottom. And go north. I mean, more and more and more and more and more. I mean, you could easily do 100 grand on this. 6 figures, not a problem. The biggest thing is when you know you're dealing with a judge who has very little patience and will jump up your butt like that, Nas, you make sure you've got it wired tight. You've got your case ready to go. It's nice and clean and streamlined. There's, you understand the rules and you understand you have to abide by them. I'll Whoever said they're showing it, Lisa, do you have a link to where they're showing it? Because I can't get it to show up.
Higher prices.
Yeah, guys, I can't get it to load. No, the dog always barks at everything, so don't. There's no intruder. Well, the lawyers for Rittenhouse were on point, but it's because they were competent trial attorneys. These guys, I don't know what their deal is, but they're acting like they've never done this before. It's weird. I mean, this is the one attorney, Ivory Lamar. He, it's not some crappy put together website. This guy looks like he's got his stuff together. I mean, you look at him, it's nice and sleek and snazzy. You'd think he knows what's going on, but the quality of his website does not match the quality of his capabilities. Go to his About tab? Okay. Simply put, Ivory Lamar Trial Lawyers was founded to help people. This firm has personally witnessed the impact that subpar legal counsel, no shit, it can have a hell of an impact, can have on a client. But Ivory Lamar Trial Lawyers' goal is to provide high-quality counsel in order to reshape clients' lives. Well, he's definitely reshaping Theodore's life and help him face a brighter future. Maybe brighter under the lights of his prison cell, I don't know. This may seem far-fetched. Well, yeah, you pulling a dub out right now is pretty far-fetched, buddy. But this firm can quickly work to alleviate the stress you're experiencing. I don't know how the hell you're doing that. Oof. It's not necessarily that he's not humble, Stacy. It's one thing to talk shit if you can lay it down and score home runs. Yes, I do think for him, he is looking at the headlines and trying to make a name and using this as a cause to celeb. Very much like Kyle Rittenhouse's first attorneys, John Pierce and Lynn Wood, used Kyle as a vehicle for a political gain. I think that's happening here, and his attorneys are kind of out of their element. They thought they could use this and gin up some controversy and kind of phone it in and say it's all about race, but this is one where it wasn't. Hey, Em, I didn't see it. Can you put it back up? Hey, Em, if you have that link, throw it back up there so I can click on it and find it. You can post it. I'm not gonna. You can no. Don't worry about spamming it. Don't be afraid to throw it out there. Yeah, guys, if you're watching it somewhere, please just tell me where you're watching it, and I'll look for it real quick. Well, guys, yeah, sorry, I can't find it. I'll keep looking real quick.
Let me tell you guys a little bit about Melio. Through the Melio platform, you can manage all your vendors and bills and organize.
For all the reasons I've already indicated, and it's cumulative, that testimony related to anything being shown to Mr. Black from any video is not allowed. I'm sustaining the objection. In terms of the defendant,
More clarification we need on Dr. Black. So I understand it's exposition testimony and there are parameters established based on our notice. The question is, what are the limitations? But I believe the state believes that it should be able to have a wide open cross and open the door if it wants, and then we can rehabilitate. But we're not prepared to get into that because that's never anything that we've noticed on.
Mr. Huebner.
Your Honor, I plan to cross-examine the witness based on his testimony. I don't know what defense counsel's talking about.
Right, I agree. The state will cross based on the testimony. If the state goes in cross-examination, no pun intended, across the line, I'll tell them that and stop it. Let's now discuss the defendant. And I don't know what the state's going to ask on cross. I don't know what the defense is going to ask on direct. I know what my ruling is regarding the testimony. I expect both sides to comply
Hang on, guys,
with
I'm
the
fighting
court's
for it.
ruling.
Give me a second.
There's the issue of the defendant. I'm presuming based on everything the state, strike that, the defense has said in their opening and to me multiple times that the defendant is going to testify. So there's a question of the defendant's prior record. It's my understanding from what was discussed earlier that he clearly, apparently, has a carrying concealed weapon conviction.
There we go.
Then there's the fact that the defendant pled guilty a couple of days ago, actually last week, to felony bail jumping and misdemeanor bail jumping. So I'll hear from both sides briefly as to what your position is on
There we go, just fixed it.
number of prior convictions if and presumably when the defendant testifies. Mr. Huebner?
Your Honor.
All right, all good. Thank you, M. I appreciate all you guys
He's got
listening.
3 convictions.
By that you mean the CCW, which was when?
Hold on, let me pull that up. I apologize.
So it's the state's position that the answer to that question should be 3. The CCW and the 2 convictions, meaning the bail jumping felony and bail jumping misdemeanor that the defendant pled to a week ago, correct?
Yes.
All right, Mr. Ahmad.
And I can tell, just so the court is aware, and I don't want to misstate anything here, that CCW conviction is in 2000, and it was a 2016 case. The defendant was convicted of that in October 10th of 2017, so 5 years ago.
Mr. Ahmad.
Judge, so as the court knows, there's a variety of factors the court can look at. So the language under the case law is whether to admit evidence of prior convictions. So how do we interpret prior? I've looked at the case law, Judge. I don't know if prior we're referring to prior to the time he testifies, but I think that generally that would be the rule. But in this case, we have something unique in that he's pled to offenses that he was charged that are of the same date and same transaction.
All right, well, let me jump in. I'm taking it under advisement. Both sides have to provide me with some legal research,
That's a fair
case law,
argument.
or authority in this matter. I'm confident this is not the first time in the history of American jurisprudence that this has occurred. Find me a case from Wisconsin, find me a federal case, or find me persuasive authority, and I will weigh that along with the fairness and the equity related to the pleas. Obviously, the CCW counts as 1 conviction. Clearly, at a minimum, when the defendant testifies, he will have to answer at least 1. The question will be whether it's 1 or 3, or I guess arguably 2. So I think really it boils down to 1 or 3. So both sides, please do some research. Provide me with a case in Wisconsin if there is one. I'm certainly not aware of a Wisconsin case, but the federal system has a very similar process and similar rule. Find me a federal case from the Eastern District, or find me some persuasive authority. It's almost 5 o'clock. We're going to break for there. I want all the defense witnesses ready to go at 8:30. That means Dr. Black, the police officer or officers, the ME, and obviously the defendant will be present. We're taking a break. I want everybody back at 8:15. We'll start as close to 8:30 as possible tomorrow. We're off the record. We're adjourned. Thank you.
All right, well, that's it. Gabby, no, I was trying to scramble to find coverage while you were listening, but it does sound like Dr. Black's going to testify. That should be interesting. He is a use of force expert as well as a technology expert. He's got an impressive resume. The guy's in, Army Special Forces for, career Army Special Forces, then was in law enforcement for a very long time. So he should be very interesting to listen to and hear him talk about use of force. So we didn't get to hear that during the Kyle Rittenhouse trial. I mean, overall, did the defense really present anything that helped them? No. I think I typed earlier to somebody, this is like a bombshell full of mouse farts. There was nothing here. This did nothing. I mean, it probably bored some jurors, but it certainly didn't move the needle towards not guilty. Let's see, what else are you guys asking? I don't think it's as open and shut as you'd think, but like I said, his attorneys are making it very easy to see it that way. Okay, guys, so the goal is tomorrow. I'll start it up. I'll start the live stream up. I'll let it just go through, and you guys will kind of be left here amongst yourselves. No, Wisconsin does not have the death penalty. They have not had the death penalty since the 1850s. It's a very long time, but they haven't had it. That said, though, there's only one state in America that's never had the death penalty, and that's Michigan. But yeah, Wisconsin has not had the death penalty for 170 years now. Oh, Gabby, I hope you get better. I'm gonna cut this out if that's it. Yeah, thank you guys for all your words. I appreciate it. I mean, I'm serious. Any other questions about anything at all? Hold on. Did the thoughts? What was the guy in question along with the video he created? Did the judge have a rule on that? He might have Lil Miss while we were away, but I have a feeling he kind of took a dump on that and denied it Century. Sky, trials will change not only from state to state, but within the same courthouse. If there's every judge has their own rules on how they like to do things. So one judge you have to play it a certain way, another judge you can play it a different way. So it's not only state to state, it's county to county, and sometimes within the county, courtroom to courtroom. Laura, this will be uploaded on my channel, so if you want to find it, you should be able to find it there. So just subscribe and you should be able to look for it. Looking to see if you guys have any other questions real quick here. Yes, they're going to start at 8:30 right away. So 9:30 Eastern Standard Time, 8:30 Central. I don't know what it is in the mountains, but I think it's like 7:30 out on the Pacific. Thank you, Lil Miss. Tomorrow's a pretty uneventful day in court. I just have to be there. Thankfully, nothing too serious is happening. Hey, Dragon Ball Z, sorry, I was just checking for something real quick. Yeah, there's no more audio. The trial's done for the day. Sorry you came in late. Yeah, like I said, sorry, you just missed it. Well, guys, I think that's going to be it for right now. Looks like guys don't have too many more questions for me. I'll probably just talk to the mods real quick and ask them. You know, we could talk a little bit about that, mods, if you want to stick around. But everybody else, you guys are going to take off. We're done for the night. Have a nice night. Thanks for sticking around. I appreciate your views. And, yeah, I hope you guys come back in tomorrow. And then, you know, just keep sticking around watching. I post a lot of videos as is. Cheryl, tomorrow, if something goes wrong, I think it's going to be on its own. I won't be able to be here to mess with it because I'll be out and about in court. The only thing I think might change is it's snowing like crazy here, so I may have a couple hours of things to do before my afternoon court. Hey, Adrena, Stacy, and GPS, do you guys know how to do it so I can get you guys into a stream or chat where we can just talk, or do we have to wait for everybody to leave? Oh, Stacy, my first name's Sean. No, Gabby, I wouldn't kick you out. That's a good idea, Drina. I guess I'll do that real quick. If you guys are already subscribed, that's not an issue. I'll just start a new stream. If anybody is still watching, thanks, guys, but we're done for the night.